1910, Edmond Locard. One sentence, every contact leaves a trace. That single line is 115 years old, and it is still the rule we live by. When an attacker touches your network, when malware writes to a registry key, when someone exfiltrates a database to a thumb drive, they leave fingerprints, and they take fingerprints with them. The job of a CHFI, find those fingerprints, prove they belong to the right person, and convince a judge to admit them as evidence. That's it. That's the whole field, on one slide. 5 rules govern every forensic decision you will make. Memorize them. Rule 1, Locard's exchange. Every contact leaves a trace, already covered. Rule 2, the scientific method. Your conclusions must be repeatable, verifiable, and survive peer review. If another examiner cannot reproduce your result, your evidence is junk. Rule 3, objectivity. You are not a prosecutor. You are not a defender. You find facts. If the data exonerates the suspect, that is the answer. Examiners who chase a theory get destroyed under cross-examination. Rule 4, contemporaneous documentation. Document as you act, not at the end of the day, not from memory. Now, time-stamped, signed. Rule 5, preservation. Never alter the original. Hash the drive. Image the drive. Work on the image. The original sits in evidence storage, untouched, until the trial is over. 5 rules, every exam question, every court case, every investigation you will ever run. Even perfect technique does not get your evidence into court. You also have to clear an admissibility standard. In U.S. federal courts, that standard is Daubert, set by the Supreme Court, 1993. Daubert has 4 prongs. Your methodology must be testable. It must have been peer-reviewed. It must have a known error rate, and it must be generally accepted in the scientific community. The older standard, Frye, comes from a 1923 D.C. Circuit case. Frye asks one question: is your method generally accepted? That's it. Some state courts still apply Frye. Federal courts replaced it with Daubert. If you are testifying as an expert witness in federal court, and CHFI examiners often do, your tools, your methods, your training, all of it has to pass the Daubert test. Use an unvalidated forensic tool. Opposing counsel will get the evidence thrown out. Memorize this distinction. Digital forensics is not one job. It is 6, each one its own artifacts, its own tools. Computer forensics, Windows, Linux, macOS endpoints, file systems, registry, event logs, prefetch files, browser history, tools, autopsy, FTK, NCASE, X-Ways, network forensics, traffic, PCAP files, NetFlow records, firewall logs, intrusion detection alerts, tools, Wireshark, network miner, Zeek, TCP dump, mobile forensics, iOS and Android, call logs, SMS, app data, GPS history, cloud sync remnants, tools, Celebrite UFED, Oxygen Forensic Detective, MSABXRY, Magnet, Axiom, cloud forensics, AWS, Azure, GCP, SaaS platforms. Your challenges, data residency, shared responsibility, and the fact that you only have API access. Tools, AWS CloudTrail, Azure Monitor, GCP Cloud Audit Logs, Malware Forensics, splits in 2, Static Analysis, disassemble the binary, Dynamic Analysis, detonate it in a sandbox. Tools, IDA Pro, Ghidra, Cuckoo Sandbox, AnyRun, Virus Total, Email Forensics, Tracing Origin, Detecting Spoofing, you live in the headers, PST files, OST files, MBox archives. Tools, Kernel OST Viewer, Aid for Mail, FTK with the email module. Bonus 7th discipline, database forensics. Transaction logs are your primary artifact. They show which who changed what and when. Platforms, MySQL, MS SQL Server, Oracle, PostgreSQL. For the exam, know all 6, plus database, plus at least one tool for each. Most organizations get this part wrong. They wait for the incident, then they panic. Forensic readiness is the opposite. It is a NIST term, the ability to maximize the use of digital evidence while minimizing the cost of an investigation. The keyword, proactive. You set up the capability before anything bad happens. 7 components. 1. Identify what evidence you could collect legally. 2. Map where that evidence lives. 3. Define your collection tooling and train staff to use it. 4. Write your chain of custody templates. Store them somewhere you can grab them at 3 a.m. 5. Set retention policies that match legal hold requirements. 6. Coordinate with legal counsel before the breach, not after. 7. Train your first responders. When the incident hits, an organization with forensic readiness opens the playbook. An organization without it makes it up as it goes and watches its evidence get thrown out for chain of custody violations. Forensic readiness on the exam, proactive before the incident. Forensic investigation, reactive after. They are not the same thing. NIST gave us the canonical forensic process. Special publication 800-86. 4 phases. In order: collection, examination, analysis, reporting. Collection: identify, label, record, and acquire the data. Preserve integrity throughout. This is where write blockers, hash verification, and chain of custody documentation live. Examination: forensically process the collected data, automated tools, manual review, whatever the situation requires. Extract the relevant artifacts. Analysis: take those artifacts and answer the investigative questions. Build the timeline. Connect the dots. Use legally justifiable methods only. Reporting: write it up. Describe what you did. Explain how your tools worked. State your conclusions. Document the impact. Collection, examination, analysis, reporting. Memorize the order. The exam tests it directly. 5 roles you need to know. First responder, the first person on scene. Could be a cop, could be IT, could be a SOC analyst at 3 a.m. Their job: secure the scene, prevent contamination, document the environment, collect volatile data first. Order of volatility: RAM first, then disk, then archive storage, and critically, do not power off the system without thinking. Live data may need to be captured first. Forensic examiner, that's you. You do the actual work: create images, verify hashes, analyze artifacts, maintain chain of custody. You hold a cert CHFI, in case certified examiner, access data certified examiner, expert witness. You, in court, you explain technical evidence in plain English to a jury. You must meet Daubert. You must defend your methodology under cross-examination. Different from a fact witness, who only testifies about what they personally saw. Attorney guides the investigation to keep evidence admissible, issues legal holds, issues subpoenas, coordinates e-discovery in civil cases. Incident response team handles containment and remediation, but the IR team can destroy evidence if it is not careful. Forensic team and IR team coordinate from minute 1. 6 steps, same shape every case. Identify, find the evidence and where it lives. Preserve, write blockers, legal holds. Do not touch the original. Collect, image the disks. Dump the RAM, export the logs. Examine, process with forensic tools. Extract artifacts. Analyze, build the timeline. Draw conclusions. Present, write the report. Take the stand. The CHFI exam will test you on the order and the boundaries between phases. 2 things to remember from this objective. First, Locard's exchange. Every contact leaves a trace. That is your operating principle. Second, NIST 800-86. Collection, examination, analysis, reporting. That is your operating process. Lock those 2 in, and you have the foundation for every CHFI question, every investigation, every court appearance for the rest of your career. Next up, Objective 1.2, Legal Framework and Evidence Standards. We dig into how the law actually treats digital evidence, where chain of custody comes from, and what gets your case thrown out before it ever reaches a jury.